With regard to the government order dated 19 September 2022, whereby the government proposed to create supernumerary posts. Kindly will underline this: government proposed. Cabinet memo says the School Service Commission proposed. These are very interesting feature. And whereby the government proposed to create supernumerary posts for assistant teachers. Government order came as a policy of the government for accommodating waitlisted candidates. That is also the government's stand. The commission, merely being a recommending authority, no role to play other than implementing the directions of the School Education Department, for which issued the notice dated 14th October 2022, which is merely a schedule for conducting and counseling of assistant teachers for work education, physical education. I deny that the notification referred to are in complete violation of Rule 12.4 of the Rules 2016. I say that Rule 12.4 deals with the upper primary teachers.
Misquoting. This 12.4 is misquoting.
Misquoting. 12.4. 13.4. 13.9. That I have placed also on the last occasion. Then that means I deny that there has been any violation of Rule 39 of the Rules 2016, as the panels and wait lists were published according to the said Rules 2016. But this is a very important submission on behalf of the School Service Commission. Therefore, this wait list, Millard, is related to 2016 selection, where ratio 1:4 was maintained. With regard to the petitioners being called for verification after creation of supernumerary post and creation, I say the question did not arise that the supernumerary posts were created for leftover waitlist candidates who are actually successful candidates who could not be recommended for want of vacancies. And my rule, my lord, prescribe the detailed method of, my lord, declaration of vacancies at the time of advertisement and final vacancy 15 days prior to final publication.
Yes, that Rule 8 possibly is.
Rule 8.
Kindly explain this situation, this 1:1. Supposing...
I just give a shubha. Now, my lord, I have vacancies, suppose X.
No, first of all, this supernumerary post would be, treated as vacancy.
Of course, so. But they admit that these waitlist candidates, they could not be accommodated because there is no vacancies. Vacancies were notified as per the rules. And, my lord, as per the notified vacancy, my lord, they have invited for further interview, for a further schooling or merit assessment, 1:1:4 ratio. If there are not 100 vacancies, they have to invite 140 people. By that process, the list is prepared, and according to the merit position, the top meritorious persons will not who goes to vacancies filled up. The rest persons who are called for interview are placed in the waiting list. Why waiting list? Suppose a person who was found to be in the merit panel within the 100 declines to join. Then, during the validity of the panel, person at the waiting list is offered.
No, whether this can be treated as vacancy.
Of course.
If it is treated as vacancy, then 13
has to be first.
Has to be first.
That they say the consistent pillar stand of the authority.
And in that event, the petitioners had a chance of
everyone had the opportunity, Millard, to get a call.
How then? By the cutoff mark will be lowered.
These are the now new vacancies. And the persons who are waiting may not be in the waiting list which has exhausted. They are also entitled to participate. When they are a vacancy, then you have to fill it up according to the procedure laid down under the law.
Mr. Bharati, make it clear. Now, waitlisted candidates, why the candidates have been put in a waiting list? Because there were not sufficient vacancies there.
Therefore, these vacancies become beyond the declared vacancies.
Beyond the declared vacancies.
If it is beyond the declared vacancies, then you cannot appoint from the said recruitment process.
How your chance come then?
If vacancy now we have created X vacancies, it's open, who are entitled to apply as per the EGB, apply for these vacancies.
So this is a natural selection process.
Normal selection.
Normal selection process. But in a situation where if you treat this as vacancies, if you treat these as vacancies, how your chance?
I will not treat this as new vacancy. They say these vacancies are created after the selection was complete, after the appointment procedure was complete. Therefore, these are vacancy creation. They say we have created this for the waitlisted candidates. Why waitlisted? Because they could not get chance in the declared vacancy.
Now, I want to understand one thing: how if it is treated as vacancy,
at least.
how the petitioner's chance comes?
Yes, but if it is a vacancy, then what would be the duty of the government?
To declare it and you take it in the new selection process. In this selection process, if these vacancies, this supernumerary posts are treated to be a vacancy,
then what you have to do, you have to invite 1:1 ratio all the persons who are waiting. May not be the waiting list, but their standing might be below the so-called waiting list. But still, they would be.
But they must have the beyond the cutoff mark.
Yes, might be so.
1:1.
Now, cutoff mark changes as soon as you create the vacancies. The cutoff mark was created for the purpose of filling up the declared vacancies. That cutoff mark cannot come for the purpose of consideration of new vacancy.
So you say that as soon as it is a vacancy, your whole thing
has to do afresh,
including the fixing up the cutoff mark.
Absolutely, everything would be changed. You admit that we created this vacancy to quell the administration. I mean the agitation. That is the admission in the cabinet memo. Since the people were agitating, to stop the agitation, we have decided to create post for the agitating group. Can state do this?
At that point, our waitlisted position cinch can expect.
And since the and since the waitlist conception is related inextricably with the selection procedure of 2016, this waitlist has nexus with the select list. If the select list is complete, waitlist vanishes. Apart from the question of expiry, the purpose of waitlist is completely abolished as soon as the vacancies are filled up.
So creation of supernumerary indicates that vacancies have been filled up. There is no vacancy occurred due to non-joining or otherwise.
But if non-joining, then the person who is at the waitlist, he will be offered. And
but
this
creation indicates that there is no such situation.
Vacancies are complete. We cannot appoint you. Don't agitate. We are creating vacancy for you. This is fundamentally against the basic principles of Article 416 and in violation of the recruitment rules. I shall take your lordship to law later. But I am trying to emphasize on the fact that this is the persistent stand of the state and the School Service Commission as well, that the vacancies were created for a particular section. It may be for a privileged section. I use this term. Then, and I complete this paragraph 9. They were dealing with 13.9. 12.4 was a mistake. They have also say that, however, just down the middle. However, I deny that there has been any violation of Rule 13.9 of the Rules 2016, as the panels and waitlists were published in accordance with the Rules 2016. This is, in my humble submission, full stop. You admit that you have published it. Therefore, exercise of power under Rule 2016 is exhausted. Then they say, and in the ratio 1:1:4, with regard to the petitioners being called for verification after the creation of supernumerary post, I say that the question did not arise as the supernumerary posts were created for the leftover waitlisted candidates who are actually successful candidates who could not be accommodated for want of vacancies. Now, how could they be successful? We are also successful because we could not be accommodated in the vacancies. If there were vacancies were created, I'd create 20,000 vacancies. Everybody is successful. This statement of SSC is very interesting. On the other hand, petitioners on the other hand were unsuccessful candidates who were not even eligible for participating in the personality test. Because this personality test was vis-a-vis declared vacancy. If the vacancies initially was which you have declared and subsequent vacancies, automatically you have been called personality test. But this statement of School Service Commission
So it cannot be says that you don't have any interest
Well, I am most
in
vitally affected.
creation of the supernumerary
This
post.
is absolutely, well, that if I may use some, the argument doesn't hold any water. This paragraph 9 of the School Service Commission affidavit is very important and interesting. Then kindly come to me, Lord. In paragraph 10, they are dealing with Wemashi, so I am not now troubling my Lord with that. No, actually.
You may have come back again.
I have to. I have to. Now, that this is interesting, kindly come to paragraph 14. I say that this is important. Because I had pleaded before your Lordship, which has been accepted by the division bench, upheld by the Supreme Court, that after the creation of this, School Service Commission filed application before the court saying that we have created this post to accommodate illegal appointees. As soon as we took up the point, they wanted to withdraw. The Honorable Court refused. They preferred appeal. Appeal court giving reason judgment refused. That no, it cannot be withdrawn. Now they are dealing that. With regard to supplementary affidavit, I say that the said supplementary affidavit has been filed annexing one can application so-and-so, which has been filed in connection with WPA so-and-so, Shondip Prasad and others, which has no connection with the instant heat application, as the case of Shondip Prasad deals with the selection of Group D staff, which is a totally different selection process. Moreover, the purpose of creation of supernumerary as prayed for in the said can application is totally different from the purpose of creation of supernumerary post. That I have placed with that cabinet memo, this stand that is betrayed that. As proposed by the government order the 19th May. Hence, the question citing the can application while challenging the government order does not arise. It may be noted that the Commission has given specific written instruction to the advocates to withdraw this 8th can. But the facts are out. Now, the cat is out of the bag. Now you cannot just say, I will put the cat again into the bag. Therefore, the both state and School Service Commission, Lord,
For a minute. A division bench judgment.
I paste that division bench judgment. But in this connection, I'll be placing that this is the division bench judgment. Lordship has seen so many repetitions.
Show me two paragraphs from this judgment which deals with the locus standi point.
Yes.
Paragraph 70 or somewhere I have seen.
No, the Honorable bench has dealt with subject wise.
Paragraph 128 onwards. Recording sound.
I'll kindly come to Lord, page 159. You can mention it. 158, what's the maintainability?
Where I wanted to.
Paragraph 128 under the heading maintainability. Having understood the parameters of the matters, this is very important, which my Lord also not thinking, what is the parameter within which locus has to determine. Having understood the parameters of the matters, which we have to decide the issue of maintainability of the writ petitions needs to be answered. Persons opposing the writ petitions have questioned their maintainability. In order dated so-and-so, the Honorable Supreme Court enjoined maintainable writ petition have been questioned on the ground of delay, laches, and writ petitioners being at the behest of unsuccessful candidates who had participated in the selection process and failed. Various authorities have been cited at the bar on such an issue, which we shall consider presently. But I am not detaining my Lord with the authorities submitted by the respective parties. Then kindly turn to Lord, page 164. But I am not really detaining my Lord with the issue of laches, acquiescence.
147.
Now kindly come to analysis of the cited authorities on maintainability. 146. Authorities cited at the bar have underscored the underlying principle governing delay, laches, acquiescence to defeat a writ petition to be estoppel and prejudice. In the facts and circumstances of a given case, if the writ petitioner is found to be guilty of such delay and laches so as to have allowed third-party rights to intervene and attain finality, kind of underline this. third parties' rights have been allowed third party rights to intervene and attain finality, then such a writ petition is not to be entertained. Similarly, when a writ petition is found to be acquiesced in a particular course of action, he is held to be estopped from questioning the same. However, these defenses of delay, laches, and acquiescence would not have application when the existence of fraud is established. No appointment can be made after the expiry of the panel. As the panel is not a perennial reservoir of appointments. Panel is valid for declared vacancy and for the specified period. Now, this will have apt application before your lordship also. Appointment towards future vacancies cannot be made from the panel. Appointment made in violation of Article 1416 of the Constitution of India are nullity. Courts have no jurisdiction to direct appointment to be made beyond the validity period of the panel. Now, I don't think your lordship need to go further on this particular issue. The nature of the writ petition. Paragraph 150, I just giving the glimpses of facts in that issue. A candidate who had participated in the recruitment notification for third regional test 2016 for the post of clerk has filed so and so. He had avowed in his writ petition that the board had issued a provisional appointment letter in his favor for such post on March 2020. He has stated that such letter was issued 3 days before commencement of the COVID pandemic. He had gone to school at which he was given appointment but was not allowed to join. He had prayed for a writ to allow him to join the post of clerk. Writ petitioners in so and so alleged that they participated in the selection process for Group D. They have claimed that the authorities had acted dehors the 2009 rules by not publishing the 4th phase counseling list and not calling the petitioners thereto. They have claimed that the authorities did not prepare and publish the panel in accordance with rules and that the entire panel was full of discrepancies. They have alleged that the entire selection process lacked transparency. They have claimed that several candidates holding rank below them had been given appointment. Similar allegations here. They have given details of some of the persons who were ranked below them but given appointments. They have sought appointment to the Group D post and cancellation of the notification declaring the panel to be expired. Other factors are there, many things. And all after having considered all this, the court says this is a issue is no issue at all. Then kindly come to me, Lord. Paragraph 160, delay on the part of the petition and maintainability, because they might indicate this.
So 163 take 160.
163 on a purposive reading of the writ petitioners, one cannot arrive at the explicit finding that any of the writ petitions or the prayers may have been barred by law or do not disclose a cause of action. But I have been repeatedly arguing this before your lordship. The writ petitioners are entitled to approach the writ court with the prayers made on the basis of the pleadings as existing in the writ petitions. At the bare minimum, the writ petitioners allege misadventure by the authorities in the selection process. The writ petitioners are the participants of the selection process, albeit unsuccessfully by most, in respect of which they allege misadventure. They are entitled to a fair consideration in the selection process, a fundamental right under Article 14, denial of which they allege in the writ petitions.
166.
Then lordship may skip over. Kindly come to paragraph 166. The nature of misadventure alleged is such that such allegation cannot be dismissed at the threshold or as not disclosing a cause of action to approach a writ court, or such allegation being barred by law must not be inquired into by a writ court. Quite to the contrary, if the statements made in the writ petitions are taken as true and correct, then they make out a case of transgression of fundamental right to be treated fairly in a selection process undertaken by the state authority. Whether the writ petitioners will ultimately receive any relief on the basis of the pleadings of the parties completed after affording the parties opportunity of filing affidavits and the prayers made in such writ petitions would be a different issue. On the face of the pleadings contained in the writ petition and taking such pleadings to be true and correct, on the principle akin to consideration of an application under Order 7, Rule 11 of the Code, it cannot be said that any of the writ petitioners are barred by law or does not disclose a cause of action, and that any of them must be dismissed as not maintainable at the threshold. This was my argument in brief. Now, in this background, you
Can take the pain of just mentioning the paragraph numbers. Mr. Dasgupta, have you taken a note of it? What are the paragraphs number?
128.
Act on bolo.
146, 147, 160, 160.
দর্শক লিখছে
Tell me.
জোরে বলো, জোরে।
146, 147, 160, 163, 164, 166.
167, 168.
Yeah, 167
167
and 160.
Therefore, here, my lord was kind enough to confine also the creation of supernumerary post. Now, state Millard in his affidavit said we have administrative power. That is beyond constitution. Now, kindly Millard takes up the Constitution of India. Let us see Millard the executive power of the state. কোথায় দাও তাহলে দেখিয়ে দিই this SSC they filed with a supplementary affidavit.
No.
But this is of 19th February 2024. We kindly turn to paragraph 4. But if your lordship kindly permission, may I put on the hat?
Yes. Yes.
এই তো জলটান তো kindly come to paragraph 4.
এটা শুনিয়ে দাও ফাইলটা হলুদ ফাইলটা কোথায়?
Paragraph 4 of
এটা
19th February.
Paragraph 4 of the supplementary evidence.
Yes, supplementary affidavit dated 19th of February 2024, affirmed by Mr. Amalesh Raut. Paragraph 4. It may be noted that by an order dated 19th of May 2022, which is challenged before your lordship, the government created supernumerary posts for assistant teachers for class 9, 10, 11, 12, and for non-teaching staffs group D, C, to accommodate those waitlisted candidates who were adversely affected due to rank jumping, supersession by some other holding a lower rank. Same order also created a total number of 16 supernumerary posts for physical and work education for all waitlisted teachers for co-education physical education. After the creation of said supernumerary post and subsequent receipt of 1600 vacancies, well, underline this, subsequent receipt of 1600 vacancies from the school education department. Now kindly just recollect the rules. When the final vacancies are approved by the state, then will the advertisements. On 29 September, the commission published a notification in its website for conducting the counseling of the remaining waitlisted candidates. Therefore, admittedly, my lord, when the counseling begins, it means, my lord, they take these vacancies, my lord, which are subsequently created as part of the original vacancies and not declared. In the division bench judgment, lordship is pleased to note that no appointment can be given beyond the declared vacancies and after expiry of panel. Which was held between 10th November and 16th November.
What is the meaning of remaining waitlisted?
Yes.
Remaining?
I know some waitlisted, this is a huge scam. Some waitlisted blood who were ought to be waitlisted got already appointment. But even the investigation.
I can only derive a meaning from here. Of course,
they can
the
explain.
commission has to explain. Remaining possibly indicates that from the wait list, somebody has already been given appointment.
That's somebody who were entitled to get because of someone has refused. Out of 100, 5 might have refused. Therefore, go down 1, 2, 3, 4, 105, they were afforded the appointment. Therefore, the waitlisted function became completely exhausted. Therefore, they say remaining waitlisted. And then the counseling process comes.
The rule prescribes how the persons or the waitlisted candidates would be appointed.
Yes, rule says.
Rule prescribes the procedure.
Rule
There may be
says electrically it has been placed.
1:1.4.
1:1.4.
To that ratio, there will be the calling for the counseling. From there, a main panel and a waiting list is prepared. Rule must have indicated or has prescribed
Indicates
that how this waitlisted candidate will be given appointment.
that is prescribed in the rules. That as
Can you show me?
yes,
the
kindly turn to the rules. Rule is at page 248. At page 250, rule 13 is the method of selection.
252.
252, yes. Rule 13. This is the method of selection. There, my lord, sub-rule 9 says
1:1.4.
then the final list is prepared. Kindly come to sub-rule 11 is very important. The Central Commission shall also prepare and publish in their website a panel of candidates category-wise equal to the number of vacancies and category-wise waiting list for the rest of the candidates from merit list who were not included in the panel. From the panel, the Central Commission shall prepare region-wise list of candidates on the basis of option exercised by the candidates and publish in their website, provided that the written answer scripts of OMR shall not be reviewed or re-evaluated. Provided then second proviso, also that the number of qualified candidates to be called for personality test shall not exceed, mandatory, 1.4 times the number of actual vacancies published at the time of declaration. The rule was so compact to prevent any sort of extra mechanism. Rules were prepared to ensure that no bad water rushes in. Then kindly come to what would be the situation when someone in the list does not join.
Kindly declared at the time of result of written examination as per the clause B of sub-rule 3 of rule 8.
You cannot go beyond this. Statutory rules. State also cannot go beyond this. Now kindly turn to 16. Validity of panel and waiting list. Both have validity. Each panel and waiting list.
This is admitted position. This is admitted position.
Admitted position, but fantastically they say it stands automatically extended. Affidavit says. Then we have 16 first proviso, provided that names of candidates shall not be recommended against any post other than the post applied for or against any vacancy which has not been notified. Where do we get authority to create posts for waitlisted? The waitlisting is prepared because of notified vacancies. And then you, in the affidavit, say, being a statutory authority, that they are qualified, others are non-qualified. If this is not without scam always doesn't mean without exchange of money. This is a scam when you deliberately violate the rules to accommodate XYZ. Then notwithstanding anything contained in sub-rule 1, a panel, waiting list, merit list prepared by each of the regional commission before coming into force, that remains. Then 17, recommendation of candidates for appointment. My lord was asking me what is the mechanism. Well, may I place it, my lord? The regional commission shall hold counselling with a view to
rule
17.
Yes, very well.
Now the regional commission shall hold counselling. Now that in the affidavit they say that we have started counselling for the waitlisted candidate, for which subsequently posts were created. Not had Shukumar been alive today, well, I don't know what would have written. Notwithstanding anything under sub-rule 1, a panel, waiting list and merit list prepared by each of the regional commission, I'm not sorry, 17. The regional commission shall hold counselling with a view to recommending the name of the candidate from the list for appointment against each vacancy. Thereafter, the regional commission shall recommend the name of only one candidate against each vacancy depending her position in the panel and availability of requisite vacancies, and a copy of the letter recommending the name shall be sent through speed post. A recommendation letter shall remain valid for a period of 90 days from the date of issue. Well, all these aspects were taken into consideration. Then kindly come to the sub-rule 5. If a candidate refuses to accept her allotment of post during counseling, or Central Commission gets information from any school or from the District Inspector of Schools or otherwise that a candidate recommended for appointment has not accepted the offer of appointment or joined the post within the stipulated period, or such a candidate refuses to accept appointment, or further scrutiny, it appears that the candidate has misrepresented the facts. All these provisions are there. Then the Central Commission may do away with his name from the panel and will be deemed to have been depaneled and recommend the name of a candidate from the waiting list, strictly within the validity period of the panel and waiting list. It's a complete procedural letdown to prevent any hanky-panky. Now, here, Lordship notice the Commission has been empowered to remove that person on a further screen. It appears that the candidate has misrepresented the facts. But here they say, oh, yes, there are mismatching. Now, because there are a mismatch, I create new posts. Correct? Law says if there are mismatches, remove them and give it from waiting list. You want to keep those mismatching candidates well valid happily, and without following the rules.
There is no allegation against the waiting list candidates that there is.
No, the allegation against the entire selection process.
So that is the other part.
No, therefore,
We are
this waiting list is the outcome of the selection process. Waiting list.
I wanted to know. It's when the selection process in 2016 has got two parts. What is the reason why this was not included in the main selection process of
the
work education?
The vacancy selection procedure is well let down. Lordship has seen, I mean, they say this again. Therefore, they say that the first declaration of vacancy at the time of advertisement, then further.
No, Mr. Bhattacharya, what I want to know, there is a 9, 10, 11, 12, Group C, Group D in one. And why these two have been...
Incidentally, these petitions were not before the Honorable Court. Then.
Why these two separate...
this is the physical education and the work education is a different craft, different stream. In only confined to upper primary school. That's why this.
That was 9, 10, 11, 12, Group C, Group D.
Just interrupting. Today, in 2025, the rules are one rule. 9, 10, 11, 12 and upper primary, one comprehensive rule. In 2025. In 2016, the rules were different. Different means there were separate rules for upper
2016 rules, but
yes,
but two
different
2016
rules.
Two different rules.
Yes.
Three different.
Therefore,
three different rules. There are 2016 rules, 2019 rules, then 2020.
No, 2016 there are two rules for 9, 10, 11, 12.
9, 10 separate.
One rule.
Three rules. 9, 10 is separate, 11, 12
is separate. I am teaching.
9, 10 and 11, 12.
Upper primary.
All three.
Three rules.
Now, therefore, now the issue is specifically confined to supernumerary post. Now, I was pointing out, my lord, the supplementary by Mr. Amalesh Chandra Raut.
Paragraph 6.
My ultimate argument would be, my lord, SSC, English February. That because of the. They Joshua Dea Choda.
2024.
No, I was at paragraph 5. After the creation of said supernumerary post, might be the risk of repetition. Therefore, the creation of supernumerary post is after the selection is over. On 29th of September 2022, the Commission published a notification dated 14th October on its website for conducting the counselling. Now, when you see the conducting the counselling of the remaining waitlisted work education, physical education. Therefore, on that date, you accept that the waitlist candidate the wait list was alive. And when you say counseling, therefore you are going back to 2016 rules. You know my source of power is the rules, not beyond that. A copy of the notification annex. In terms of the said notification, the counseling was concluded and the recommendation letters are issued in favor of all the remaining waitlisted candidates. However, when order dated so and so, board was restrained. Then kindly come to paragraph 7. It may be noted that at a much later stage, the Commission, in a totally different set of writ applications challenging selection process with regard to appointment of Group C, Group D, had filed applications for appropriate order. The said applications were filed in the month of September 2022 for creating supernumerary posts to accommodate the candidates whose appointments were subsequently found to be invalid, so that there have been loss of job of the said candidates, which means a livelihood. However, the Commission did not place the said application, prayed before the Honorable to withdraw the said application. As I have already said before Lordship. Now, kindly come to paragraph 11. It is abundantly clear now how far the state authorities can create misgivings that the supernumerary posts created by state by order dated 19th May 2022 are different from the supernumerary posts mentioned in CAN application. The supernumerary posts created by the state had already come into existence and were made for accommodating waitlisted candidates who had found their positions in the waitlist as per their merit. The supernumerary posts mentioned in CAN filed by the Commission have not yet been created. Now that in the background of this, I am compelled to take your Lordship to the Cabinet memo to show how far these authorities, either they got themselves confused or they are trying to confuse the whole world. Yes.
Kindly clarify this paragraph 11.
Yes.
I'm a little bit confused.
No, I'm confused. In the kindly takes me the application which they are referring to, that is also annexed.
19 May 2022 are different from supernumerary posts mentioned in CAN application of the Commission.
Yes.
So, on 19th May 2022, then when the application was found or filed?
This application was found by them.
This one, the earlier before the.
Yes, that is part of annexure.
But September 20.
The CAN is a part of annexure. It was filed in September. It is September 2022. Specific date is not mentioned. 27 September.
Annexure R1 is the application.
Yes.
27 September 2022.
Now kindly come to paragraph 6 of the application. I need to clean.
So, there, in addition to this, there are more supernumerary posts to have.
That is they want to say.
Such exercise means not to proceed with such exercise means
Not to proceed with the
creation of supernumerary posts.
no, such exercise means that they mean to say in paragraph 6 really follow. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified as humbly proposed, that apart from giving recommendation and appointment to the genuine candidate as observed by this honorable court by order dated 21st September, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid since the matter was pending. But they all knew ultimately all this will be declared invalid.
But the paragraph 11, what I could gather, that there is one set of supernumerary posts under notification dated 19th May
There is no other.
2022.
But that is their misunderstanding. They probably wanted to communicate that Group C, Group D, 1911 is different from physical education.
But by one notification,
Yes,
such
kindly come to cabinet memo once again. I was saying this is very important.
Supplementary affidavit.
Supplementary affidavit আছে cabinet memo আমাদের supplementary affidavit.
petitioner's supplementary affidavit.
Affidavit dated 19th June 2025.
Now, is cabinet memo again I just refer to my lord. This is proposals and I got it. Proposals for creation of supernumerary post of assistant teachers including physical and work education. Therefore, this is the comprehensive cabinet memo. No separate. Then Lordship may skip over my lord, item 1 which relates to 9-10. Item 2 relates to 11-12. Item 3 rather item C. Group D, Group C. Then kindly come to E. For the teaching posts of physical education, work education, a total vacancies of 2,373. This is declared vacancy. Total numbers of candidates recommended was 2,194. The panel expired on 11 December 2019 and the decision is taken on 2022. They recognize this fact. Grievances on the said recruitment. A number of cases are pending before the Honorable Single Bench and Division Bench of the Honorable High Court, alleging that recommendations appointments were given either in violation of merit or recommendation appointment given beyond panel and wait list. Same allegation. Allegation against all these appointments were same. In the meantime, one Shoma Das, the petitioner alleged that in spite of her merit in wait list, she was not recommended, whereas candidate not even in the wait list got recommendation and appointment. The Honorable Court requested the Principal Secretary to look into the matter of the petitioner so that if possible she can be engaged in future. The School Education Department also considered the proposal of Commissioner of School Education with regard to the demand of waitlisted candidates, physical and work education for appointment in their favor. Now here is interesting development. This Shomadas issue was also raised before the Honorable Supreme Court. The Honorable Supreme Court said Shomadas was an exceptional one. We upheld that, but rest we set aside. Which includes, my lord, the decision-making process of this memo is set aside. But the Honorable Supreme Court did not permit CBI investigation. That the cabinet memo, that was the view, the cabinet
CBI investigation to the extent of
creation of supernumerary.
No, the observation is very. Where is that second part order? Order of the Supreme Court.
In respect of the creation of supernumerary post. The order is 8th of April. I am reading out not loudly. We have Joshua copy.
We have copies. Supreme Court. Next one, another is there. Another is there. Okay. Main order. 3rd April order. No, 8th April order. 8th April order. 8th April order is there. 8th April order is also there.
In paragraph 52 of our judgment, dated 3rd of April, it was held that the issue with regard to the direction for investigation by the Central Bureau of Investigation vis-a-vis the decision to create supernumerary post would be dealt with separately. Therefore, this is the issue. And there the Supreme Court says, Next page, my lord, the last but one paragraph. Having regard to the aforesaid discussion, we are of the view that the High Court was not justified in referring the issue of creation of supernumerary post pursuant to the cabinet decision for investigation by CBI. This was the direction issue, and the court says that this we set aside this part, but this will not in any way affect. We, however, clarify that our observations and directions given in the present order are limited to the extent of directions for investigation into creation of supernumerary post and do not in any way.
But Mr. Bharat, please see this page 2. Perusal of the note dated May 5, 2022.
Yes.
Which note is referring to?
Cabinet decision.
Which makes out a case of cabinet decision.
Yes.
Reflects that it was recorded that the power of section 19 and this one may be used in respect of wait-listed candidates, but the same shall be subject to outcome of the pending
litigation. Yes.
Section 19.
Direction by which they say section 19 empowers the state give direction to the School Service Commission.
Very good. This case was taken by the cabinet decision such and such. It may be relevant to take note that clause 2 of Article 74 and
Yes.
clause 3 of Article 163 of the Constitution of India, which specifically state that the question whether any, if so, what advice was tendered by the Council of Ministers to aid and advise of the President or tendered by the ministers. এটা ছিল না ওখানে? এটাও লিখে দিলাম, মাফ করে দিলাম। Yes, minister to aid the advice of the President or tendered by the ministers of the cabinet to govern shall not be inquired into any court. However, clarify that our observation and direction given in the present order are limited to the extent of the direction of investigation into the
Yes.
creation of to that cabinet decision.
There was no criminality. Now kindly takes up the constitution.
Cabinet
Cabinet memo was, sorry, I was on the cabinet memo.
রাখো যেখানে ছিল।
Now, my lord, this is important because this goes against the affidavit by the School Service Commission. School Service Commission says that the supernumerary post was proposed by government, but the cabinet memo is otherwise. The third page, proposal 2, item 2, proposal of Central School Service Commission and Commissioner of the School Education. But this runs contrary to the affidavit by the School Service Commission. The Central School Service Commission, the chairman of the Central School Service Commission, beat a letter dated 22nd April 2022, placed a report to the state government stating that 5,261 numbers of candidates have been affected by rank jumping. Admission of candidates have been affected by rank jumping in the first SLST 2016, third RLST 2016, Group C and Group D staff. 1932 post of assistant teacher for class 9-10, 247 post assistant teacher for class 11-12, 1102 posts for Group C and 1980 posts for Group D. And if all the similarly placed candidates like Shoma Das are to be recommended, then 5,261 posts are required to be created. Again, new post.
It is the proposal of the commission. What is the difference between that application and this proposal?
The affidavit says this is the decision of the state. I just once again said.
This was the proposal of Central Commission.
Central Commission initiated the proposal. What I mean to say, the Central Commission, not having appreciated that there are illegalities galore, the agitations were going on, therefore we propose this.
But then what is the difference between the stand of SSC disclosed in that application?
I want to submit to Lordship that all the authorities were really fighting against each other to shelter them. Because everybody knew this is illegal. But somehow or other I have to save my face. Therefore all these things are coming. Now Shoma Das to be recommended like that. Now the Shoma Das Supreme Court has not got sanction, but not the others. But I would submit, Lord, that is my conclusion when I'm concluding, that by virtue of the Supreme Court judgment, Lord, everything goes constitutionally. I'll come to that. Then the chairman, West Bengal School Service Commission, Further, VD is later dated 25th April 2022 placed a report to the state government. But I am skipping over the Group C, Group D because they will say different thing. The West Bengal Board of Secondary Education also confirmed the fact that such appointment of non-teaching staff beyond the list, as reported by the Commission. The chairman of the Commission further stated that for teaching posts 9, 10, 11, 12 who do not feature in any list, either in panel or in wait list, should be cancelled by the Commission without waiting for direction of the Honorable Court. Similarly, for cases relating to non-teaching staff Group D who do not feature in any list, panel, wait list, so and so should be cancelled. Then, Commissioner of School Education, VD's proposal dated 4th May 22 has proposed to create 1600 numbers of supernumerary posts, break up 750 for work education and 850 for physical education to absorb all waitlisted candidates of physical and work education subject to validation of panel. Where is the validation of panel? How could the School Service Commission
Not at all.
How could the School Service Commission, without going based on recommendation, say we have recommended the names, thereby alluring the unemployed youth to feel more agitated and agitate against the councils? These are the allurement. You yourself says that it is subject to validation of panel, and you know there was no validation of panel. But it requires, in my humble submission, very strict measure against these officials who are public servants paid out of the public exchequer. They are creating dissension. And dissension against the entire system. Now, department's views. Well, I'm straightway coming to the issue in question, 3 Roman 2. 1600 supernumerary posts be created for absorbing all waitlisted candidates.
So the proposal was moved from the end of the
Commission. And then they say absorbing. Whom do we absorb? Those who are not in employment, how can they be absorbed? That will be fresh recruitment. The absorption in the service jurisprudence has different meaning.
The person is still that who has the recommendation was made by.
But I don't know who was then the chairperson. Recommendation was made in 2022.
Still, he is the chairperson.
Yes. But this is the basic foundation of cabinet decision, and the state says that we have administrative authorities beyond constitutional authorities. It's the affidavit. But kindly come to that stateway. I take a lordship now. Question of law, facts. I have already delineated. Now we'll kindly turn to Article 160.
চলে গেছে মেলা কিছু সব এখানে ডিভিশনটা ঢোকানো এটা কোথায় ছিল এই দেখুন সাপ্লিমেন্টারি এভিডেভিট দেখি স্টেটে খাতায় আছে এই দুটো এভিডেভিট কোথা থেকে বার করেছিলেন দেখুন ডিভিশনালের সাপ্লিমেন্টারি এভিডেভিট এগুলো going to the constitution, can we take a break for
Yes. Now, kindly turn to the stateway Article 162. That Article 162 is the state's executive power. Extent of executive power of state, subject to the provisions of this constitution. The executive power of a state shall extend to the matters with respect of which the legislature of the state has power to make laws. provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. Therefore, the executive power, which they say that we have executive power, cannot rise above the constitution. And the public employment is governed by Article 14 and 16. This is now a settled position, which is a part of the fundamental right. Therefore, whatever executive power you have, you can exercise in the field where you have power to make laws. And in this respect, my lord, you have already made law for recruitment of teachers. Therefore, you cannot have any other power beyond the laws which you have made in exercise of the Article 162. And vis-a-vis this, just I take the liberty to point your lordship the stand of the state. Kindly take once again the affidavit of the state. It's affidavit of state by the first affidavit, 28th of November, 2022. There is a fantastic way of claiming. Kindly come to subparagraph F. I just not place the important reading or submission in the fourth line from the bottom of the same paragraph. Hence, it cannot be said that the teachers of a recognized aided institution are not in public employment. In fact, they are supporting in public employment. They have a government Article 1416. Then, accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. And the larger framework of Constitution is only Article 162. And that Article 162 empowers you to work subject to the provisions of the Constitution. This is no power beyond the Constitution exercised. Therefore, they themselves have admitted that this has been done beyond the Constitution. Now, this is the constitutional position. Now, let us see how these issues.
They are suggesting that it is within the larger framework of Constitution. So they are required to trace their such power within the Constitution.
Yes.
Has it been explained anywhere in this?
Nowhere. No, there's no other power except Article 162.
You may not be knowing.
I always accept, my lord. We live to learn. I cannot say that. But so far, so my knowledge goes, Article 162 is only authority under the Constitution to exercise the executive power in the field which under that 7th schedule, second list, you can exercise. And in exercise of such power, you have already made the rules for recruitment. Therefore, you have no other power. Now, just for my interest, I will just refer to your lordship. Since this division bench has decided and the Supreme Court has upheld, few paragraphs relating to this supernumerary post. Now,
First, give me the paragraph number.
yes, I would just, I'm really tempted to read paragraph 350, 351, 352, 350, 34, 356, 357 and 350, up to 359 rather. I am tempted to make this, read these paragraphs which have some philosophical connection to the society.
360
And 360 also, yes. Now, the educational institutions have been admired, accorded special place in the society, and have been ring-fenced against the ills that may befall the society. Civilizations have made such attempts so that the future generation develops in an environment conducive for attaining the dreams of an individual student and caters to the holistic development of the student. Educational institutions are expected to produce better and evolved citizens who would be in a position to contribute to the society, nation, and to the mankind. Parents put their wards into educational institutions with the expectation that such educational institution imparts a level of education so as to assist the wards to develop into a better human being. Human beings are in control of any educational institution as in other institutions. If the teacher and the non-teaching staff of such educational institutions or even a portion thereof obtains appointments fraudulently, such teacher or non-teaching staff immediately forfeits his integrity, honesty, and his ability to impart wholesome education to a child in such an educational institutions. An educational institution must be protected against such elements attempting to let anyone permeate into it. It is therefore imperative and in the beneficial interest of the society that such elements are removed from an educational institution. Then important. SSC has filed CAN 2 such and such have placed before a lordship, seeking permission for creation of supernumerary post for the illegal appointees. When objected to by the writ petitioner, SSC had sought to withdraw such applications. Learned single judge had declined the request for withdrawal by order dated so and so. A special petition had been preferred where an order dated November 25, 2022 had been passed. In the two applications noted above, the learned single judge had directed CBI to undertake investigation in respect of the creation of supernumerary post. Division bench had refused to stay such directions. Supreme Court had, by order dated November 25, stayed such direction. Stay granted by the Supreme Court in November 25, 2022 was against the interim order passed in the pending writ petitions. Lest it be contended that we have not directed measures to be taken in respect of creation of the supernumerary post on final hearing of the writ petitions and the appeals, we deem it appropriate to pass necessary directions with regard thereto also. Investigation by CBI with regard to the creation of supernumerary post is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by SSC for state-funded schools, knowing fully well that such appointments were obtained beyond the panel and after the expiry of the panel at the bare minimum. Now, this is important for our purpose now. The enormity of such wrongdoing is accentuated by the fact that the illegal appointments are sought to be confirmed in educational institutions. Persons involved in such decision-making process therefore have exposed children to persons who obtained their employment through fraudulent means. Unless there is a deep and pervasive connection between the persons perpetuating the fraud and the beneficiaries thereof with persons involved in the decision-making process, such course of action in resolving to create supernumerary posts to protect illegal appointments is inconceivable. Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether such violations have resulted in criminal liability should be investigated into. Because criminal liability portion is stated by the Supreme Court, but Article 14, 16 has been upheld. Therefore, this supernumerary creation was also a part of the division bench judgment, which deals with the violation of Article 14, 16, which has been upheld by the Supreme Court. The next paragraph. Since at least a portion of the beneficiaries of the scam, that is to say that some of the persons who were appointed beyond the panel and after expiry of the panel and appointees submitting blank OMR sheets stands identified, it would be appropriate to direct such persons to return the benefits. I'm not troubling my lot with that. Then, exception. During the pendency of these proceedings at para 360, Learned single judge had taken note of the plight of one candidate, namely Shoma Das, and directed registration of a writ petition number with regard thereto. Shoma Das has subsequently filed in which an order dated April 18 was passed by a learned judge. There the learned judge had taken note of the medical condition of Shoma Das and requested the state government to consider providing her an employment purely on humanitarian grounds. In course of hearing the matters before us, it has been submitted that the court should make an exception so far Shoma Das is concerned, since an appointment was purely on humanitarian grounds, which has been upheld by the Supreme Court also. We have considered the order dated so and so and find that request for consideration of appointment of Shoma Das was made purely on humanitarian grounds due to medical conditions of such person. Mrs. Shoma Das had been granted appointment by the state government purely on humanitarian grounds. Consequently, we propose not to disturb the appointment as state had granted the appointments on humanitarian grounds. She will stand outside the directions issued hereafter. On this discussion, ultimately, the Honorable Court was supposed to set aside the employment appointment. And the cabinet memo is basically based on Shoma Das's case.
No, so far the directions or to what extent the division bench considered this creation of the supernumerary post.
To the extent of Article 1416.
No, so far the affidavit or the application filed by direction based on that.
Yes, yes.
Whether the what is the subject matter of challenge in the writ petition? Somewhere around it has been covered by
But in my petition here,
whatever the
our challenge is without
supernumerary.
no, entire selection.
No, so far the supernumerary. Your challenge to the extent of 19th May 2022 notice, creation of physical work. Whether that notice, 19th May notice 2022, as anyway the division bench has.
No. Division bench did not really go into the nitty-gritties of 19th May notification. Division bench while found that supernumerary posts are created to accommodate the illegal appointees on the basis of the.
You have read somewhere, this is beyond the life of panel.
Yes. So that this is here also. Kindly, I was placing the paragraph
147
না এখানেও আছে
is not a legal work. No appointment can be made after expiry of the ban.
Yes, paragraph 355. Paragraph 355, it says, my lord, that the appointments were obtained beyond the panel and after expiry of the panel at the bare minimum. Here also, my lord, the appointments ought to be given not after expiry of the panel. And that expiry, my lord, is stated to be violation of Article 14 and 16.
Where?
My lord, next paragraph 357.
357.
Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether the violations resulted in criminal liability, but I am not troubling, that was said. Therefore, that apart, the other portion of finding that this violation of Article 14, 16 is upheld by the Supreme Court. Now, I will just place the order of the Supreme Court 1 second now. It is third
April, 8th April.
First order. Now, the Supreme Court judgment, my lord.
Yes.
3rd April, where the court finds.
45.
Can he come to paragraph 46? Anyway, he wants me to read 45. It's not necessary 46, because Article 14, 16. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violated Article 14 and 16 of the Constitution. As such, all the appointments are cancelled. But this is a conclusive finding of the Honorable Supreme Court, that violation of Article 14, whether you are found to be tainted or not, is immaterial. Here also, my lord, this notification itself is not a violation of Article 14, 16. And when on the affidavit they say we have executive power under the Constitution. Now, I may just point out once again, I have pointed out, Lordship, the affidavit of state. Affidavit of state, that paragraph is very interestingly drafted with all authority.
Election process held in 2016.
My lord.
A part of which has been found to be wholly polluted. How can the other part be so?
How can it revive?
Or like Ganges?
Yeah, that is not. How can it stay even for a single day? But if
it is your
But if the supernumerary creation of post, they say subject to the pending of the repetitions. They do not say that subject to the pending of the repetition before Lordship, which was challenge after the supernumerary posts were created. But they say that all these petitions are pending before the High Court. I will show me that this states stand first. Justice Chidambaram order first. Chidambaram. The state stand was that the supernumerary post, though created, no appointment was given because of pendency of petitions. Therefore, they also knew. Joshua without a copy. This is the first order before the Supreme Court when state moved and got a stay. It is 7th May order.
Paragraph 22. Paragraph 22.
Done.
Yes, sir. We WP number first of all. Pending. 22.
Yes, will kindly come to Milord. Paragraph 21. Got it. On May 1922, the government of West Bengal issued an order creating 6,000 students of supernumerary posts for teachers, non-teaching staff for absorbing the waitlisted candidates and directed that the appointment letters to such waitlisted candidates shall be issued in terms of the recommendation SSC subject to the outcome of the pending litigation before the High Court.
This writ petition,
Yes,
all these three writ petitions,
all these petitions.
5 writ petitions, all these 250 to 256 are before me.
Hey, কি বলছেন যশ?
All these 250 to 256 are before me.
WP number
এই petition গুলো তিনটে আছে, আর তিনটে কোথায়?
দুটো এখনো অ্যাসাইন হয়নি এবং এইটা স্যার আপনি পড়ে দেখেন, এটা স্টেট বলেছিল যে এই
সেটা জিজ্ঞাসা
আজকের লিস্টে তিনটে আছে।
three matters are pending before your lordship and other three I'm told not yet
yet
assigned. এটা বাদ দাও, যা আছে আছে।
তিনটে আছে, ওয়ার্ক ফিজিক্যাল বোথ আছে।
স্যার এইটাই নাম্বার হলো 25,056। এটা একটাই
ও
আমার
তাই,
হাইফেনটা হবে না।
oh that I am also outdated. The writ petition number is 250256, not with a hyphen.
Oh, acha, acha, acha.
আমাদের এটা নম্বর কত?
2502।
Yes, this is the
Oh, 250, not 2, 25056.
Yes.
And 2 is excess.
that the hyphen is not is
And 2 is also excess.
2 is also.
25056.
Yes.
এটা
now, Lord, therefore this is the stand. I'm just reading once again, Lord. During the course of hearing, this court has been informed that petitions under Article 226, this petition has been instituted before the High Court to challenge the order of the government creating the supernumerary post to accommodate the waitlist candidates. By an interim order, the government order creating the posts have been stayed. Now, but this stay was not stayed by the Supreme Court. Since Lord, I had the privilege to,
Was it prayed for?
because
at
they
one
prayed for that CBI investigation against the state for creating supernumerary posts. Please stay that.
CBI inspection.
CBI investigation.
But since the stay is already there,
No argument, because that was the one, the sheet anchor of the defense. Since no appointment could have been given because of stay, therefore there is no criminality.
no, the background, I don't know whether at that point of time you were there or not.
No, I was there physically. That's my difficulty.
No, not that. In this matter, two things proceeded parallelly. The one is this challenge. Simultaneously, the direction of the coordinate bench to go into the CBI inquiry as to the decision
yes.
of that. That traveled through division bench to an SLP
Yes.
before the Supreme Court. Supreme Court state division bench has recorded. That SLC is pending. At that point of time, this challenge was shown. And Mr. Gopal Mukherjee.
Yes,
the
he said that
learned
this issue might be.
No, I must say, he
Yes,
was a
okay.
man of stature. When I put him this question, that if you can assure this court that this challenge
Would not
or
be
the power of state to create such post is under challenge here, this issue will not incidentally would be raised in that SLP. He then took specific instruction of his counterpart in the Supreme Court, said, no, that assurance I
cannot be
cannot.
given.
Matter was time to time deferred.
Yes, yes.
Even the state took a stand that no, we are not going to give any appointment now.
That's clear.
So why the matter was deferred?
But because of that,
Pending issues are there. In the meantime, division bench.
and then my lord directed the state to file an affidavit specifically stating that
Exactly.
whether this will clash with the Supreme Court determination.
They refused to.
SLP
Therefore, my lord, this stay by this court, my lord, in respect of appointment vis-a-vis supernumerary post was their, my lord, defense.
To get the stay of the
Criminal
CBI
investigation.
inquiry.
Paragraph 47. It will only restrict to Sumanda's thing is back.
সেটা বলেছি already. My lord, I already, my lord, probably I'm repeating, my lord, being
Prompted by
poked by, I don't say prompted. That the Supreme Court dealt with the Shumadas issue, paragraph 48.
on 3rd April.
Yes, that's similar to the base order.
Yes, lastly.
Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment held that the appointee Shumada shall be allowed to continue on humanitarian grounds. That's important. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. Therefore, many, don't take it otherwise, many dramas were created in the court of the Supreme Court. Certainly, my lord, some visually disabled persons, they were brought in court to argue, in spite of their senior counsel having argued. The Honorable Chief Justice heard them and said, I'm not going to give you benefit. And that's the finding at page 48. Shumada is exceptional. She was suffering from cancer. The court not felt if some concession can be given. Therefore, that cannot be, my lord, a ground. That's why I say that will really contradict the main finding of rule of law. That is paragraph 48. And rule of law is Article 1416. And the state in its affidavit firmly says that we have our administrative power. I had pointed out to your lordship note, I again point out, my lord, that this is the stand of the state at page 8 of their affidavit, subparagraph F. 28 November. দেখালাম তো এইমাত্র ও নামিয়ে নিয়েছেন
আচ্ছা আমার এই জায়গাটা কোথাও হাতটা ওভাররুল করলাম আছে হাতের কাছে
subparagraph F. E could have placed, I'm not troubling, my lord. They say the validity period has expired is an irrelevant consideration for creation of supernumerary posts. This is where, yes, that is subparagraph E, last line. Subparagraph E starts at page 7, continues to page 8. State, having made statutory rule, now says that is immaterial consideration. Then it is stated that subparagraph F is very interesting. This is source, they say. Last 3 lines. Accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. This could have been a new addition to the constitutional jurisprudence. Statute maker says that the statutory empowerment is immaterial, higher constitutional authority. What is this? Article 162. What Article 162 says? Subject to provisions of the Constitution. You can take a decision in the field which empowers you to make law. And having made law, you take a stand saying that this is immaterial.
Is it lack of understanding or to save a situation?
To create more chaos in the society, not to save a situation. Lordship can take judicial notice of this fact that this has created huge chaos in the society. I do not travel beyond this, but this has, everybody must have taken note of this fact.
Who is at the receiving end?
Bikash Ranjan Bhattacharya. Why did he raise this issue before the court?
Or
why did he argue that the entire panel should be set aside? He should have argued that the corruption should be prevailed.
So ultimately the candidates,
ultimately they are misguided people. Anyway, I restrain myself not from making this statement. Therefore, the stand that we have a constitutional power belies the specific words mentioned in the Article 162. There is no other power by which state can exercise executive power to do something. Now, the next question will be whether the judicial review is permissible. That point has been mentioned and taken by the court to judicially scrutinize the order passed by a cabinet. It means that if the cabinet tomorrow says that I let all the terrorists who are imprisoned free, that decision cannot be reviewed. That's the stand, but that's not the law. I will take a lordship in law.
just
প্যারাটা থেকে প্যারা 37 ওটা 22টা বলেন, প্যারা 37 স্পেসিফিকলি বলা আছে যে ওরা প্যারা 37 ওই দিন অর্ডার।
যখন বলি তখন বলা না কেন?
আমি তো বললাম যে তোমার ফ্রন্ট করে
ঠিক আছে।
স্পেসিফিকলি বলা।
বিপি সিঙ্গেল ওয়ার্কার।
BPC 2010 666.
কি আছে কি বলে?
Did you cite that 2006 to SCC, the Vaghela's judgment?
Yes, not in that matter.
In some of the Article 16, which finds place in the Part 3 of the Constitution relating to a fundamental right, provides that there shall be equality of opportunity of all citizens in the matter relating to employment or appointment in any office under the state. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in the public offices. The word employment or appointment cover not merely the initial appointment, but also other attributes of service like such and such.
But it was cited by me in Darjeeling matter.
Yes, you had cited,
But-
but I have used it in another matter.
There is all
In Arjigor matter, I have used it.
similar judgments are only common in both matters.
So Article 14 and 16 ultimately has to be adhered to.
But it's a fundamental right. No one has any authority to act in breach of fundamental.
162 does not give that much of power.
It starts saying subject to provisions. The constitution makers knew that may at some point of time some people may come to power and they say we are the monarch, therefore we can do whatever we like. And Ambedkar said, don't forget, we have a written constitution, we have a limited government. These issues were discussed during the constitutional debate. We have a written constitution and this is a limited government. No one has authority to act beyond constitution. Now the heated debate is going on. The Supreme Court has said that even the governor and the president doesn't have the ultimate discretion to sit over the decision. They have to give a decision within a certain time. Normally in Madras governor matter, the president has been pleased to make a reference. Supreme Court will reject it, I am sure.
Here, even the legislature has framed a law, has legislated a law,
The field is occupied.
occupied field. Now, what is this saying? That it should fall under larger framework of constitution.
know.
So he is given by the
This statute.
legislative field goes banks on the constitutional provision. That is under Article 62. 62 limits the power subject to the other provisions. So now you will be citing judgments now?
Yes, I will say.
Can we continue when?
Whatever time your lordship allows me.
Because I don't know who is for the state now.
Advocate General is there.
Very well, because this week it will not be possible for me to accommodate. Let me come back with a fresh mind.
Where are you going?
Andaman circuit, then I will take. Let some fresh air come.
Anyway, subject to court's convenience, lordship.
Because I know that this will be an interruption on your argument, but I need to close down it very quickly. So what about, you would like to cite some judgments. Now this is
The facts are now, so far I am concerned, clear. I shall not give authorities.
you have
because
given
many-
outline of it in these 2 pages.
Not today's argument. Today's argument I shall give next day. This is my first day argument.
You make
Action with
it and give it to me so that I can go through it
action
and we can avoid repetition.
no repetition. এরপর আরেকটা পাতা আজকে তো দিই।
একবার শুধু প্যারা 37 একবার দেখে
Yes.
একবার প্যারা 37
একবার।
Please, Milan.
একবার স্যার
But my juniors again wants me. I am just in paragraph 37 of first this order. The court has been Supreme Court pleased to record. Para 37, I'm reading out. Mr. Rakesh Dwivedi with Mr. Neeraj Kishan Kaul, Senior Counsel appearing on behalf of the State of West Bengal.
7 July order, first day order, 7 July.
3rd April order,
7 July.
7 July.
7th July, like
That is
In
day, first day.
2025?
That is from the June.
7th May. July and May.
But he is perhaps reading that portion where they submitted to the Honorable Supreme Court that no appointment is going to be made.
Pending repetition.
7th May.
Okay, 7th May.
Yes,
Pending repetition.
Well, it's-
yes, I have.
That seems
That no appointment, this council submitted appearing for the state that no appointment whatsoever has been made in pursuance with the order of the state government dated 1922, which in any event forms the subject of a pending repetition.
Where here you are from?
The
Where?
paragraph 37 of the order.
This is order dated,
7th of May, first order,
but the SSC affidavit has already said that recommendation has already been made.
yes. The recommendation was made, but not appointment.
7
No
pending.
Appointment. The recommendation appointments are different.
No appointment given. Therefore.
No,
So, yes.
it is my as a
What? Tell me. What is? Tell me what you want.
kindly do not
Tell me, na.
I
Tell
am
me.
trying to emphasize that Milord, one order is there which I will invite my senior Milord to distinguish, because the challenge thrown to this entire process at some point of time, Milord, he had the occasion to represent us in 2019, and the challenge failed. I am handing over a copy.
At a time, you.
Milord, at
the time.
the issue is I'll hand over a copy of the order. Milord, when he is going to make his submissions, I will request, Milord, because there is a complete controversy, Milord, going on inter se the applicants, because Milord, it is an
No, I understand. He appeared once for.
not only he, Milord, they visited the place.
Oh,
after,
oh.
those things are there.
He will answer to that. Raise it in
We
reply.
still
to it.
say without, we have said that the appointment
So
should
the
be
thing is,
made
Milord, Mr. Bhattacharya
following
had the
the-
occasion to appear for us, for some of us, not all of us.
not to seek illegal appointments.
Yes, question the appointment process.
Yes.
In September.
Okay, now.